So there's a reason I'm using this article. The Associated Press. Hawaii could become the first state in the United States to enter gun owners into an FBI database that will automatically notify police if an island resident is arrested anywhere else in the country. Most people entered into the RAP-back database elsewhere in the U.S. are those in positions of trust, such as school teachers and bus drivers, said Stephen Fisher of the FBI's Criminal Justice Information Services Division. Hawaii could be the first state to add gun owners. I don't like the idea of us being entered into a database. It basically tells us that they know where the guns are. They can go grab them, said Jerry E.O., a firearm and hunting instructor for the state. We get the feeling that Big Brother's watching us. Well, of course, you're right. But supporters say the law would make Hawaii a leader in safe gun laws. How so? How so? Every law-abiding gun owner is in a federal registry because the state turns it over to the FBI. How does that make Hawaiians safer? It doesn't. Allison Anderman, a staff attorney at the Law Center to Prevent Gun Violence, said the bill was groundbreaking and that she hadn't heard of other states introducing similar measures. So how do we prevent gun violence? From attacking law-abiding gun owners. That's how, apparently. Senator Will Espiro will introduce the bill, and the Honolulu Police Department said Hawaii could serve as a model for other states if it becomes the first to enact the law. What's happening is these blue states are trying to drive the national agenda now. They did it with the EPA and so-called global warming, climate change. Massachusetts versus the EPA, that was the big decision. Written by a justice who has since, he's still around. He's well into his 90s, and he's still a jerk, may I say. Now, that said, here's my concern. This just kind of triggered some thinking on my part. And this is what I fear, quite frankly. Certain parts of the Bill of Rights apply to the states. And when the Bill of Rights were originally ratified, they did not apply to the states. Did you know that? Did you know that, Mr. Producer? So freedom of speech, religious liberty, freedom of association, freedom of the press, and so forth. The First Amendment, the first 10 amendments, the Bill of Rights, are intended to protect us against the federal government. Over a period of time, without any real rationality or reason, I mean, I understand why it's done, but no real why certain amendments and not others, this doctrine developed, a Supreme Court-created doctrine called the incorporation doctrine. And so as the court started to hear cases where the court felt states were violating certain basic liberties, freedom of speech, freedom of press, due process, and so forth and so on, the court would incorporate these requirements through the Bill of Rights and apply them to states. Is that understandable, Mr. Producer? I think so. Now, this also applies, if not formally, informally, to the Second Amendment. There's been a couple of cases that have gone to the Supreme Court out of the District of Columbia, which the court has upheld the right, well, one case really, Heller in particular, I should say, in which the court held that, yes, a citizen has the right to own a firearm to protect him or herself, essentially. We have a federal district judge, Dick Leone, also in the District of Columbia, who recently ruled that the District of Columbia government's attempt to limit access to guns was so onerous that it too violated the First Amendment and the Heller decision. What happens? What happens if a 5-4 Supreme Court rules that the incorporation doctrine doesn't apply to the Second Amendment? I ask conservatives out there, constitutionalists out there, what happens if the Supreme Court says this whole notion of the incorporation doctrine, I'll tell you what, we'll be originalists and federalists for the purpose of this decision and this decision only, because that's what the left does. The ends justify the means. And the court says, well, we have a new theory. Yes, the First Amendment applies to the states. Yes, the Fourth, Fifth Amendment, that applies to the states too, and so forth. But no longer the Second Amendment. The states are free to regulate the gun ownership as the states wish. And the Second Amendment is no longer part of, in fact, or even in the breach, part of the incorporation doctrine. And they say, you know, that Second Amendment was really intended to apply against the federal government. I fear this. I really do, some point down the road. If we have the wrong court, and if the left wing controls the majority, the court is all-powerful, and this is a huge problem in this country. Only takes 5 justices. Only takes a majority of 1 to tell us what our rights are. Isn't that absurd? And to tell us what our rights are not. That's not the way it's supposed to work. And this came to me as I read this article. Here's Hawaii, through the back door, trying to expose its law-abiding gun-owning citizens to a federal database. The federal database was never intended to be used this way. So the state, rather than protecting its gun owners and its law-abiding citizens, the state turns all their names and data over to the FBI to put in the FBI federal database. And what's to stop a state from petitioning the Supreme Court and arguing, we do not believe that the Second Amendment is incorporated under your doctrine to the states, and the states should be free to regulate weapons as the states wish to. I really want you to think about this. It should be extremely concerning to you. Nobody's discussed this because I think I just figured out what they're up to, at least down the road in the next decade or 2 or so.